You're tuned to London and BBC World Service. Now we come to the Wednesday documentary, which is about some unusual and at times disturbing courtroom trials that were held across medieval Europe. These were held with all the proper procedures and solemnity of a normal criminal trial, and yet the defendants were not human. What do these cases tell us about the function of trials today? The award-winning crime author and former solicitor Frances Fyfield presents Animals on Trial.
This programme is about the ancient institution of the trial and some of the more bizarre manifestations of it as a means of securing justice. What is a trial for? Especially if the defendant has 4 legs rather than 2. For almost 1,000 years, animals, insects, inanimate objects and even corpses were put on trial in Europe. The surviving transcripts of these trials are sometimes comic and in equal measure macabre. Sadikat Kadri is a human rights barrister and the author of The Trial from Socrates to O.J. Simpson. He knows that the progress of the law doesn't always follow straight lines.
The Greeks had this idea that if a human life was taken, something called a miasma would arise. And in order to cleanse the pollution that would otherwise arise, the thing that caused the death had to be eradicated. And if the thing that caused the death happened to be an animal, then the animal itself would be put on trial. And it was, at that stage, an explicitly religious ceremony. It took place in a temple. The animal would be killed. But it wasn't just animals. It was also anything that caused the death, a toppling statue, something that fell off a building, anything like that.
It's got a certain logic to it, hasn't it?
It does.
Going on to medieval trials of animals, are the trials of animals intimately linked with religion, with Christian belief?
Actually, 3 types of legal proceedings occurred. The first were insect injunctions or creature injunctions. If there was an invasion of snails on a field, an ecclesiastical court might order that the snails be exorcised, be removed.
Much of our knowledge of these curious trials comes from Victorian historian E.P. Evans. He did extensive research resulting in a book with a grisly cover of a pig dressed as a human being executed. He explained that it was thought that the only way to deal with the ravages of miniature, noxious creatures was to resort to divine aid by catching and bringing some of them before a seat of justice, where judgment would be pronounced in a trial of sorts, conducted by the human emissaries of God. And as in all metaphysical remedies, such as magic spells, it is the ritual of it that counted for most. And thus the slightest mispronunciation of a word during a malediction or excommunication would render the judgment void.
Lord Jesus Christ, and by the authority of the holy apostles Peter and Paul, we admonish by these presents the aforesaid locusts, under pain of malediction and anathema, to depart from the vineyards and fields of this district within 6 days from the publication of this sentence, and to do no further damage there or elsewhere.
That was one kind of trial conducted by ecclesiastical courts for smaller pests. For 4-legged animals involved in untimely death, the trial was a criminal one, not totally dissimilar to what we have now, conducted by a secular judge on behalf of the state. There would be criminal charges, an inquisitor, a proper ritual, and a sentence.
There's a case from the 1450s in Burgundy where a pig was found with 6 of its piglets around the body of a 5-year-old child. And the pig was duly arrested along with the piglets.
The said pig entered during the said time the said house, and disfigured and ate the face and neck of the said child, which in consequence departed this life.
8 witnesses came along and testified against the pig.
The sentence: we, in detestation and horror of the said crime, and to the end that an example may be made and justice maintained, have said, judged, sentenced, pronounced, and appointed that the said pig, now detained as a prisoner and confined in the said abbey, shall be by the master of high works hanged and strangled on a gibbet of wood.
But the piglets, the court wasn't so sure about.
In lack of any positive proof that they had assisted in mangling the deceased, they should be restored to their owner on condition that he should give bail for their appearance, should further evidence be forthcoming to prove their complicity in their mother's crime.
There's another offence, that of bestiality, which, although not involving death, ranks as high as murder in most societies.
The Bible, Exodus. Whosoever lieth with a beast shall surely be put to death.
Animals which were caught in the act of sexual intercourse with a human being, those would be simply punished along with the human being, often punished in a very, very brutal way, burned, hanged, buried alive.
Upon Sunday last, being the 22nd day of May, betwixt 9 and 10 of the clock in the morning, they espied one Christopher Sunley being upon a mare, with his arms clasped about her loins and in beastly and unseemly manner.
But did the extreme punishment of animals reflect what medieval people actually thought about them? Here we go back to the thinkers and philosophers who came up with a theologically based idea of the place and hierarchy of animals in God's world. Professor Erica Fudge of Strathclyde University has written extensively about the complex relationship humans have with livestock, large and small.
Famously, Aristotle said humans were the only rational creatures. They had a rational soul, whereas animals only had the body. And that, while it's coming out of pagan thought, is taken into Christian ideas by Aquinas. And so it becomes a kind of absolute orthodoxy by the Middle Ages and beyond. The official view was that animals didn't have souls, so they were simply mortal. When they died, they died. They didn't have a hereafter. They were also put on earth for the use of human beings. This was the orthodox line. Someone like Thomas Aquinas took that line. For example, if you injured somebody's horse, the offence committed was not an offence of cruelty to the horse, it was an offence of property damage.
According to Aquinas, does the hierarchy that man occupies justify him killing an animal?
Within reason. If for use, for value, for eating, for example, it's your duty to eat animals, otherwise they're wasted. Killing an animal for the sake of it is a dangerous thing, not because of what it does to the animal. For Aquinas, it's what it does to your mortal soul, as somebody who may end up in hell for all eternity. If you are injuring animals, the argument is you are more likely to be injuring human beings. It's, you move from one to the other, and that's now becoming an orthodoxy in legal terms today, that people recognise the link between cruelty to animals and domestic violence, for example.
So, animals could be a catalyst to human behaviour, but that's not the same thing as considering them criminal. Professor Piers Byrne is a sociologist and criminologist at the University of Southern Maine. The trials seem not only barbaric, but also a little absurd. Were they taken seriously?
It certainly cost a lot of money to stage, so spending a lot of money implies that they were taken seriously. There was money for the holding institution for a pig, for example, who was to be tried for murder.
The bailiff has incurred the costs, commissions, and expenses hereinafter declared. Item, for a carriage to take her to justice, 6 sous.
There was money to be paid to the lawyers defending and prosecuting, and to the hangman, the executioner.
Item, for cords to bind and hale her, 2 sous, 8 deniers.
Expensive set of velvet gloves were made especially for the executioner who was about to execute a pig, so that he would not be polluted by the defiled animal.
You don't think they were laughed at? No.
No.
The notion of something was an awful sort of gruesome laughter.
There's a case from the early 1500s in Provence where a lawyer was appointed to represent a colony of rats which had invaded a village. He put up a sterling defence on their behalf. The rats were all summoned by trumpets which were blown at crossroads and proclamations which were recited, ordering them all to come to court. Everyone then assembled in court on the relevant day, including the lawyer, Bartholomew Chassenet. They waited for the rats to turn up. Not a single rat turned up.
It is nonetheless to be conjectured that some, or indeed many, of my clients may be unaware of the requirement to attend upon the court on this day.
The argument was so successful that the court adjourned in order that more summonses could be issued. The court then resumed a couple of months later. Bartholomew Chassenet was there, the prosecuting counsel were there, the judges were there, but the rats still weren't there. The court turned to Mr. Chassenet and asked him for his explanation.
And I would remind the court of the difficulties and great peril faced by my clients, owing to the unwearied vigilance of their mortal enemies, the cats, which lie in wait for them at every corner and passage.
It's a pity no record of the final judgment on the rats exists, but we do know that Chassenet, the lawyer, went on to fame and fortune. I asked Piersburn whether they really believed that rats could read a summons.
It's the big question. It's so difficult to try and put oneself back into the mind of a early modern lawyer or cleric, and whose standards of rationality and proof and so on differ so fundamentally from our own. Did they think rats could read? I doubt it very much. Could they read French or German? Or I doubt it.
They were at that point. There's something sort of humane about it in a way. They were being given sort of almost the same rights as a human being. In fact, in some cases of trials at the time, perhaps even better.
Yeah, I don't really agree that this was humane. I mean, it was human. I don't see really what was humane about it. And the majority of animals that were tried were put to death.
But what about loyalty and affection?
Was it contemplated that you could love an animal then, in the way that we might think of it now?
Well, that's a really difficult question to answer because clearly people did. And you have images, for example, of someone like Marie de France with a dog by her feet. There's a whole history going right back to the ancient world of gravestones for animals, for individual animals. So there clearly was a relationship that we would recognise as love. Mm. It doesn't get frequently reflected in writing. That's the interesting thing. And often if it does, it's belittled.
So it's only sentimental. But,
For example, ladies with their lap dogs, the argument is often that the lapdog is the second-rate replacement for a child or a second-rate replacement for a man because, of course, it's a warm object in your lap. And so the lady with the lapdog is making a serious error by putting a dog there rather than something else. And so they are not dissimilar to the way that witches are perceived to have familiars. There's something just not right about too close a relationship between a woman in particular and a dog. Men and dogs, it would often be the working dog, the hound, the hunting dog, and so that's a good virile activity.
There was a donkey which was tried alongside a human defendant in 1750 in a town called Vanves in France. The allegation against the man was bestiality, and the donkey was alleged to have been the man's partner in crime. So they were both put on trial, and the villagers came along to court, and they decided that they wanted to give a character reference in the case.
I am willing to bear witness that she is in word and deed and in all her habits of life a most honest donkey.
They didn't say anything on behalf of the human defendant concerned, unfortunately, and he went to the stake and burned. But the donkey survived.
Trials of bestiality, that universally abhorrent offence, took place all over Europe. But the odder trials of insects and animals didn't happen in England and Scotland. Why? Because it required a jury of 12 or more to reach a decision to do so, which was harder than persuading a single inquisitor vulnerable to local opinion. A different system known as deodand, meaning given to God, evolved, whereby the owner of an animal or a miscreant thing was held responsible for the harm caused and, if found guilty, obliged to pay a fine to the king. The Brits settled it with money.
There's a case from the late 16th century in Essex where two children are swimming in a pond and they drown. And their armbands, these are things made from pigs' bladders inflated with air to hold them up, are held deodand. These are seen to be responsible because they obviously didn't inflate properly. What it is I think, the legal system finding a way to pin blame, even though it's not saying, and there's an intent involved. And so the same is for example, being said about the horse that runs wild and bumps into you. The law of Diodan does, within it, have a question of what kind of dog is your dog? Know your animal. Is this horse a safe horse?
Silence in court. You are listening to the BBC World Service, the Wednesday documentary, Animals on Trial. Proceed.
Corpses would also be put on trial on the continent in particular. Again, it was a specifically continental thing. In England, suicides would be staked through the heart, but they wouldn't be put on trial. Back in Nuremberg in the 1400s, a person who died while awaiting trial wouldn't be allowed to escape trial. He'd be brought to court in manacles. The judges would address the charge to him. His lawyer would then formally consult with his client and would tell the judges that his client wasn't in control of his faculties. The judges would then order that the person be convicted and he would be taken away and hanged as though he was still alive.
What would be the purpose of that, to give a horrific example?
Partly to give an example, I think the idea was that courts didn't like to be cheated of a victim.
Something which we might still feel today.
Absolutely. I think if someone's arrested, the anticipation tends to mount. People want to see the trial, they want to go through the process. And if they simply kill themselves in the jail cell, there's almost invariably a sense that something has not been done that should have been done, that a punishment hasn't been visited that should have been visited in order to put things back to rights.
Fred West was last brought to court in Gloucester in mid-December. This lunchtime at Winson Green Prison, prison officers found him hanging in his cell. Attempts were made to resuscitate the man accused of the Cromwell Street murders, but a doctor certified him dead shortly before 1:30. Now the man at the centre of a murder case that made headlines around the world is himself dead.
One of the explanations that anthropologists have given for the trials is that they existed because there was a fear that anyone who had died in violent circumstances might come back unless trials were held, unless a proper end to a person's life, even if that end came after their death, then bad things would happen.
Sometimes putting a corpse on trial would be just a sheer expression of power.
One of the best examples of that comes from the laws of 13th century Burgundy. The province's laws said that any brute beast which killed a human being should be hanged by the hind legs. It used the term pièces d'araignée, but it wasn't only beasts that faced that punishment. The same laws, the same section in fact, specified that Jews should also face the punishment if they committed murder. There's a woodcut which shows 3 Jews being hanged being hanged upside down.
I don't think they were simply carnival, that people were just having a laugh hanging a pig when usually they hanged human beings. So it must serve a function of some kind. And I just wonder if it's not as simple as just putting things back in place.
Yes, putting something that's gone out of kilter back into order. A solution, what we call closure, something.
Yeah, and it's interesting that it takes the form of something that looks legal. Because the question then is, well, are they saying that the law is the only place that's capable of putting right, or are they saying the law has failed to control this thing, that, however much control human beings think they've got in the world? There's this aspect, let's call it a pig wandering around the streets quite freely, that is utterly out of control, will always be out of control. And that needs to be both displayed and contained in some way.
In a situation where a parent, for example, has lost a child, the hope of consolation must be absolutely immense, and there was nothing else to blame other than the animal. And even though it might seem irrational to punish the animal, in the absence of something else to blame, the trial did operate, I think, as a kind of catharsis. To a certain extent, that still continues today. Nowadays, in any trial involving injury, it's understood that victims have got a role in the trial process, and that's why victim impact statements exist, for example.
What their function was, I don't know. I mean, some things that exist don't have functions in society, and perhaps they're settling it, and it gives them comfort that the offender has been found. It's not about fairness; it's about our way of distancing ourselves from, or it's our way of showing us that we're fair by treating all of God's fellow creatures in the same way. I think in the medieval period.
Times change. Thought influenced deeds. The rationalistic and theoretical ideas of Thomas Aquinas gave way to Montaigne's essay on cruelty, which appealed more to intuition and introduced, dare we say it, the idea of mutual respect between man and animal, or at least curiosity.
Montaigne asks what I think is an absolutely fantastic question. He says, "When I play with my cat, who knows if I am not a pastime to her more than she is to me?"
The trials had lasted almost a millennia. The list of offending creatures is equally amazing. Moles, serpents, horseflies, horses, pigs, bulls and eels, weevils, worms and snails, a dolphin, a goat banished to Siberia, even a turtle dove. By the Enlightenment in the 18th century, the idea that knowledge was as necessary for guilt as a truly conscious intention came to dominate. The action is not evil unless the mind goes with it, says a Latin maxim. Knowledge has always been important to justice since Adam and Eve, but along the way, it had somehow been sidelined.
Animals are not even given the benefit of a trial nowadays.
No.
Nowadays, there are hundreds of thousands of dogs and cats in particular in Britain and the United States who are painlessly, invisibly, clinically put to death in animal shelters for crimes like homelessness or aggression. So, yes, they've declined, but they've taken a new form. The consequences for animals are the same.
Having examined, in the name of all that is just, the case for the prosecution and that for the defence, it is the judgment of this court that the harmful creatures known as field mice be made to leave the fields and meadows of this community, never to return. Should, however, one or more of the little creatures be pregnant or too young to travel unaided, they shall be granted 14 days' grace before being made to move.
That was Animals on Trial, presented by Frances Fyfield. The reader was Crawford Logan. It was produced by Matt Thompson. Animals on Trial was a Rocket House production for BBC World Service. If you enjoyed that programme, you may like to hear a podcast of one of Frances Fyfield's previous programmes on the law, The Great Writ, which is about the ancient principle of habeas corpus.